I'm Beth Andersen and my law firm is Andersen Law PC. I'm here to tell you what estate planning documents you probably need. First, the document that is most commonly thought of, your will. It is exactly as it sounds, what you will or want to happen with your things after you die. A will has other purposes too. It can include a springing trust to ensure that the person who inherits has restrictions on what they receive. The most common reason is for minor children or grandchildren. A trustee can manage the funds on their behalf. Even for young adults, you may want to manage things on their behalf so they do not burn through it. Better to use it for a reasonably priced car, education, a first home, wedding, moving for a job. Wills do other things too. You may want to decide who acts as your children's guardians or conservators, managing their money. In your will, you can also dispose of tangible property, make plans for your funeral, and decide who will be the personal representative to handle estate administration after you die. Next, you will need a living will, most document, or other advanced medical directive to make decisions before you die, such as whether to have a feeding tube or whether to be an organ donor. This is a very personal choice, and you need to think it through. Warning: think twice before you sign an advanced medical directive a hospital shoves in front of you as part of your admission. Look it over carefully. This could void other documents, so you need to understand what you are signing. I suggest going over it with an attorney if at all possible. You should have a medical power of attorney and a financial power of attorney. It is critical you appoint an agent you trust. Of all documents abused in the law, these are the ones I have most frequently seen abused and manipulated. Do not sign these over lightly. Some people also need a trust, and this is a sophisticated document that must be drafted carefully. Living trusts are necessary. For example, if you own real estate in more than one state, you do not want to do probate in 2 states. The biggest problem I see with trusts is that people do not convey their property into the trust. This can be a hassle, but it is absolutely necessary for the trust to be fully effective. You need to make sure that your real estate is deeded to the trust and that your trust is the beneficiary of retirement and other accounts. You can have a pour-over will to make sure you are covered if this does not happen, but you should do it. I really want to make sure my clients do this, and I want that trust to be fully effective. As you know, in my practice, I do encourage people to do their own legal work to the extent possible, but not for these documents. As I have mentioned, I have yet to see an online self-written will done properly. Please consult with an attorney for this important step in wealth building and wealth management. It is too sophisticated for cutting corners. I am Beth Andersen, and my law firm is Andersen Law PC, protecting your family, your finances, and your future.